Imagine this, I'm walking down the street and suddenly an object falls and hits me in the head. Oops. We're going to cover this and related topics in today's video.
And if you guys have any real life scenarios where you're wondering if you have a case, feel free to put them in the comments and we will try to answer it.
Welcome back to the Williams ELLEBY YouTube channel. Today we're going to start out with our second video in our video series of Do I Have a Case? And today we're going to answer the question,
do I have a case if I'm out walking in public and something falls on my head?
All right, so the answer to that question depends on a lot of things like where you are, what the situation entails, why it fell on your head, who dropped it on your head, and all those kinds of things. But this is a real world example or question that needs to be answered for a lot of people because it seems kind of out there, what if something falls on my head? But we've had plenty of cases where that exact thing has happened. So this question needs to be answered. So here we go.
Yes, and it happens a lot more than people would think. It does seem like a crazy example, but Joel and I just recently had a case where a gentleman was in a Home Depot and something fell on his head. So it does come up, and you know, it can get complicated quickly because there are a lot of different entities that can be involved, and who dropped, as Joel said, you know, that's usually the starting point is what caused the item to fall, because that starts an analysis of who's at fault, whether it's the property owner or whether somebody has been invited onto the property, say to make a repair or to do construction to the building. And usually the analysis starts with who dropped the item. So the short answer is yes, you probably do have a case, but it gets more complicated from there as to who that case might be against.
Yep. So let's start by breaking it down into different situations. So there's one example of where somebody may be working overhead and drops a tool or a board or an item of something and it falls and hits you. So in those type situations, we're usually going to look at the claim from an ordinary negligence standard. So by that I mean, did the person who dropped the tool or caused the object to fall do something negligent to cause it to fall? Did they have a duty to properly secure the item? Did they have a duty to guard the area where they knew people may be walking or warn that there was overhead work going on, you know, above your head, those type things? And if there is some kind of a duty to guard against this tool falling, in which in most cases there are under OSHA regulations or state-specific regulations, if somebody's doing overhead work, there's usually rules in place that they have to follow to protect people that may come in the vicinity of, you know, beneath where they're working at. So that's the first thing I'm going to look at.
Correct. And then secondarily from there, those same duties could extend to the owner of the premises. If, for instance, if there's a third party there climbing the ladder, say, to do the work overhead, then it would involve some question of, does the property owner, are they aware that they're there? Did they invite them to come there? Usually they probably did. So in that situation, that ordinary negligence standard will extend to them. You know, did they take the proper OSHA safety precautions? Did they block the area? Did they, you know, notify with a sign or a warning, or take virtually kind of those same steps, or make sure that the person who is there is acting safely and abiding by the rules set in place, you know, that ordinary negligence standard.
Yep. And the second thing we're always going to look at is what in the law, what we call the status of the person who's hurt. So if something falls and hits someone in the head, why is that person there? Are they even supposed to be there, right? So at least in the state of Georgia, we have three different types of people we look at. So we have in premises liability cases, and this is separate from ordinary negligence cases, but premises liability cases, if someone is what we call an invitee, meaning they're there to do business with someone, or they're there for the benefit of the person, the mutual benefit of the person that they're going to visit, most common examples of customer at a store, then they're considered an invitee, and the property owner or manager has a duty to exercise ordinary care to keep that store safe. So like Jared was saying, if they know somebody's going to come into the vicinity of where this overhead work is being done, then the store then has a duty to guard against it. However, if the person that comes to the store goes to an area of the store where they're not supposed to be at. So if, for example, they're a customer and they're there to buy a hammer, but they go all the way back to the loading dock area where customers are not supposed to be and something falls on their head, well, at that point, they may no longer be an invitee. They might actually be a trespasser at that point. And then if the store doesn't have reason to anticipate that the person's going to be back there, the duty that they owe is less. So in that situation, there may still be an opportunity to bring a claim, but the chances for success in that claim go down dramatically when somebody goes from an invitee to a trespasser.
And kind of building upon that, you also, the duty or the law requires that you show that the premises owner or the person there, mainly the premises owner, has superior knowledge of the harm. So if it's a situation where the premises owner has taken, steps to notify you that there might be falling objects or something in the area, they've put up a barricade, and instead you choose to go around the barricade, or you see the sign and choose to enter the area in light of the sign, well then you could be found to have assumed the risk, or just we will have trouble proving that the premises owner had superior knowledge of the harm. You now have almost equal knowledge of the harm and you're appreciating that risk, but entering the area anyway. In those situations, a lot of times that can be a bar to recovery and prevent you, even if they were negligent and they did drop it on your head, you're entering into a realm where it's going to be much harder for us to prevail on your behalf, because you've been warned and you've appreciated the risk and chosen to enter the area anyway.
Yep. And one thing that I want to distinguish here is, if you're in a store, like Jared mentioned earlier, he said third party. But what he means by third party is if the store has hired a separate company to come in and do overhead work at the store. It could be on the roof, so the area below the overhead work could be outside, it could be inside, they could be building shelves, it could be down an aisle, wherever. But if it's a third party that the store brings in to do the overhead work, there's obviously a duty on the third party to do that work safely, right? So they can't just be negligent and dropping stuff down where they know people are coming. But in the store situation, the store owner also has a duty to its customer to do exactly what Jared just said, and that's provide warnings and make the customers aware, and where appropriate, put up barriers so that customers cannot enter the area beneath where the work's being done. So there could be liability on that third-party company that's called in to do the work, as well as the property owner or the store owner if they don't provide sufficient warning that work is going to be done. Now, in a situation that's outside of the store context, say you're just walking down the sidewalk in the city and something falls and hits you in the head and you get hurt, right? Well, the analysis is a lot different there, because the owner of the area where the thing fell is not going to be in some kind of special relationship with the person who's hurt. In other words, they're not a customer. They're just a member of the public walking down a sidewalk and something is falling and hitting them in the head. So in a situation like that, there may be theories of liability against the owner of the building or the property where the thing fell from, but the much stronger case is going to be against the person who actually drops the tool or that person's employer. And in those situations, we're going to look at what are the rules. Like if you're working overhead near a city street, if you're working overhead near a sidewalk, what specific duties do you have to secure the tools? And it may be that they have to put netting beneath where they're working so that the tools are caught if they're dropped. There may be rules that require them to have, what's the word, carabiner?
Tether the
tether,
tools.
Yep, a tether, so the tools are tethered to a person so that they don't, if they do drop them, that they're still attached to the person. And if they don't do those things, if they act badly and don't follow those rules, then there may very well be a good claim against the person who dropped them. The sticky situation lots of times there is if someone has something dropped on their head from an elevated position, lots of times they have no idea where it came from or who dropped it. So identifying the person or the company responsible for doing that and dropping the tool is sometimes very difficult.
Yeah, it becomes he said, she said real quickly, especially in the construction context. There can be a contractor, a subcontractor, multiple contractors there doing the job, and it quickly becomes who was responsible for the tool at that moment, but then also who is responsible for the person that dropped the tool. Sometimes, you get into that contractual analysis of, is it the contractor, is it the subcontractor? Does the subcontractor owe money back to the contractor? And it can get very difficult quickly to figure out exactly who the correct entity is that's responsible for it.
Yeah, and it's so very rarely the circumstance where we can just say, all right, Johnny was on the roof, Johnny dropped the hammer, it hit me in the head, so Johnny's got to pay for it. Because who's Johnny's boss? Does Johnny have insurance? Does Johnny work for a subcontractor? Does he work for a general contractor? Who has the control over the time, manner, and method of him doing his job? There's all of these things that go into it, so it's very rare that we can have a simple situation where somebody drops a tool and they have all kinds of insurance, they can pay for the damage, and it's clear cut like that. The final situation we want to walk through with you is if you're a social guest at someone's house. So if I invite Jared over to my house and him and his wife have dinner one night, and I have contractors, let's just say I have a tree company cutting down limbs. Well, chances are Jared's probably going to see the tree truck when he pulls up at my house and know that they're cutting them down. But let's just say the tree truck is parked down the street. You don't realize somebody's there. There's one dude up in a tree with a chainsaw and he's cutting stuff. Or maybe not a chainsaw, because you should hear that. Just a handsaw. We're getting way out there now. But let's just say that there is an object that falls and hits Jared when he comes to my house as a social guest. In most states, there's going to be a lessened duty of care that I owe to Jared because he will be what we call a licensee, meaning he's a social guest. He's not there to do business with me. He's there for pleasure. We're there to socialize and all that. So I do have a duty not to knowingly expose him to a dangerous condition or put him in a position or an area where I know he could get hurt. But that's a lot harder to prove than me just exercising ordinary care and doing all the things that I need to do to keep my property safe. So if you're hit in the head by a falling object, you need to look at who dropped it, where were you, what were you doing there, were you supposed to be there, were there any warnings, and what rules may apply to the person or the company that actually dropped the object that hit you in the head. Yep. Anything else?
I think that pretty much sums it up.
All right. Well, and I guess one last thing. You obviously do have to prove that whatever it is that hit you in the head caused the injuries that you're claiming. So you have to prove that you didn't have some underlying condition that did not change. Lots of times insurance companies want to say, well, that person was old and they had arthritis or they had some kind of underlying medical condition that's causing this pain. That's more of an issue and less traumatic events. Most of the time, usually if you're hit in the head by a hammer that falls 20 feet, it's pretty obvious what hurt you. But don't take that for granted, because I have seen insurance companies try to argue that didn't hurt the person as bad as they say it did.
And I guess along those same lines, it kind of goes without saying, but you do need to have damages. That's the last piece of the puzzle. Sometimes, again, it's rare that a hammer hits you in the head and that you don't have injuries, but these cases can get very dense quickly and require experts and a lot of work involved. And if sometimes it can be a situation where the person was negligent and they did drop something, but luckily for you, you're not hurt. And if you're not hurt significantly, sometimes the amount of money we would have to spend in experts and fighting through the red tape to prove that they were liable could far outweigh the damages or what your case is actually worth given the injury. So I guess that is part of the analysis too, to consider how bad the injury is versus how much money would have to be kind of put into the case as far as experts and things like that go to justify the outcome.
Yeah, you don't want to spend $50,000 to get $50,000 because you then walk away with zero. So,
exactly.
Just have to be careful about that as well. All right, well, we hope this video has been helpful to you. If so, give us a thumbs up, hit that subscribe button. Otherwise, we will see you next week for video number 3 in our series of Do I Have a Case?